My leaseholder has breached their lease. Can I re-enter the property?
That's a good question. We often get that as a new inquiry, and the answer to it is it depends. Typical lawyer answer. And the answer depends on many factors. It'll mainly to do with your lease, mainly to do with statute, mainly also to do with the type of property involved. The answer will be different if it's commercial or residential property. The first thing we need to figure out is whether or not it's a breach for things like rent arrears or something like that. Different rules sort of apply there. But if you were just talking generally about breaches, what we need to assess, or if you come to us with that question, is we'll first ask you for your lease. And we'll need to see whether or not there is provision in that lease to re-enter the property, especially if it's a commercial property. And usually well-drafted leases have conditions set in if there is such a right, which need to be met as a criteria before you can take any action in that regard. And that's if you can take it, if there isn't any breach, or if having looked at your matter and we decided actually the lease hasn't been breached, then obviously that clause we're not even going to entertain looking at it, as it's a bad idea to kind of progress. So that's really where we look at with commercial leases. With residential leases, they do also have those provisions in there as well, but it's a little bit more complicated because there's a bit of extra protection when it comes to residential properties. There's protection from eviction, full stop. So there's a longer procedure that needs to be followed, leaving aside anything to do with your lease if you're going to re-enter the property. With commercial properties, there's a more practical procedure as well. If you have the right to re-enter according to your lease and you're satisfied that there are breaches and the like, there may be things that you can do which concern changing the locks, but I really wouldn't advise you to take those steps without having spoken to a lawyer about it first, because it's very time critical when you exercise those kinds of rights to re-enter and the like. And there might be other things that you need to consider. Additional advice about how this may progress down the line if someone were to challenge you re-entering the property or say that you actually didn't have the right even when you think that you did. With residential property, it's a longer process. It can take a substantial amount of time to deal with that. Usually it involves having to kind of serve notices. That's also required in the commercial context too. But serving notices, you can't just generally go in and change the locks or re-enter the property with residential cases. Generally not well advised. So you are at that point, if you are satisfied that you can enter property, you're looking at doing some kind of court action to basically effectively give you permission to re-enter, to treat the lease as being at an end, and the like. So that's what we're having to look at there. It's not a simple question. Generally wouldn't tell anyone to go ahead and just simply change the locks on any property, residential, commercial, without having taken legal advice, because it's a lot more complicated than you might first think.